I'm FLABOTA President Jeff Adelman, and this is the ABOTA Fort Lauderdale podcast, brought to you by our sponsor, Trilogy Trial Consultants. To learn more about Trilogy Trial, what they can do to help you with all your video and technical needs in litigation, go to www.trilogytrial.com. Today, we are welcoming Representative Michael Beltran from District 70, which serves Hillsborough and Manatee counties, to talk about House Bill 617 concerning law clerks. Representative Beltran, it's a pleasure to have you on.
Thanks for having me. Great to be here.
Can you tell our audience a little bit about your background and why this House bill resonated with you, why you're pushing it forward?
Sure. Yeah. So I moved to Florida about 14 years ago. I came down. My first job in Florida was to be a law clerk to a federal district judge, and the federal district clerkships, and I guess the federal court system in general, is really a model of efficiency. The computer systems used in the federal court are very efficient. Cases get decided a lot quicker than in the state courts. The judges tend to write written and reasoned opinions more often than they do in the state court system. And a lot of the legal authority that lawyers cite day to day in their law practices is generated by the federal judiciary. And so I wanted to try to replicate some of those advantages that the federal judiciary enjoys and have those in Florida, because we actually have quite a good judiciary here in Florida, especially, given the work, the last decade or two in improving the judiciary. But one of the things that's really lacking is the resources accorded to the trial court judges in Florida, particularly the circuit court judges, who tend to do the weightier cases with the larger amounts in controversy, and commercial cases and severe personal injury cases and so forth. Those are the cases that really, where the legal issues, or at least the need to brief them and to raise some of these more cutting edge legal issues, is more acute, and where so having somebody to help the judge read the briefs, write the opinions, research the legal issues would really be an advantage.
Now, in proposing this House Bill 617, it sounds like you did speak with trial court judges and litigators, and what was the feedback that you had?
Well, most of the feedback I've actually gotten was after I filed it. I knew what needed to be done. I filed the bill. I didn't have that many conversations like, should I file the bill? What do you think the bill should look like? I probably had conversations over the years, just talking to circuit court judges and others. A lot of practicing attorneys are familiar with the procedure. You go and you win the motion, and the judge turns to you and they say, write the order. And you say, okay, so you go back to your desk, you write the order, and then you send it to opposing counsel, is the custom. And you send it to opposing counsel. Opposing counsel says, well, I don't really think the judge said this, they said that, but the judge said something you didn't put in, they didn't say something that you did. And there's this whole back and forth. And then half the time you end up submitting competing orders. And, it's kind of like the litigation just by other means. And or the litigation continues even after the hearing's been completed. And so that's not very efficient for the lawyers to argue about what someone else said. It's now the judge has moved on to other matters, and they're looking at this a week or two later, trying to figure out what they said. Sometimes you have a transcript, sometimes you don't, sometimes it's not ready. And excuse me. And so it puts a lot of burden on everyone involved in the process. What I envision is you'd have a law clerk, kind of like an elbow clerk, if you will. They sit with the judge, they watch the hearings, and then they start writing up the orders as the judge goes on to other hearings or goes on to other matters. And at least then you have a neutral person writing the orders rather than an advocate. And then it's, with all due respect to the judges, it's their order. They should really write it. They're the ones who are signing it. Someone else can write something for you, but it's usually better if you can to write something yourself if you're going to be the one signing it, particularly if the two people are advocates who are obviously, they're sworn to protect their clients' interests, and so they're not going to get it as neutral or as accurate as the judge will. And so I just thought we should kind of short circuit that whole process of these competing orders And then there's a lot of other things. I mean, I'll be honest with you. Sometimes you go into a hearing and it's unfortunately it's clear the judge hasn't read the briefs prior to the hearing. And I don't even blame them given the volume of cases that they have. And sometimes the issues are very clear cut. Sometimes, frankly, if I were a circuit court judge, I'd say maybe I can wing it here. Or maybe the parties will. I've had judges say to me, tell me what's in your brief. I mean, that's concerning, but I don't want, I'm not, this is not by criticism of the judiciary so much as I want to give the judiciary the resources that they need to do their jobs well, not, say, but there are some, it's very apparent to me that the judges need more resources. And one way is by having more judges, and I've fought for that as well. The other way is by giving the existing judges more resources so they can be more efficient or so that they can leverage themselves a little bit better. And that's what I'm trying to do with this bill.
But isn't the gist of what you're saying is, I mean, the judges can only do so much with the amount of time that they have. And it sounds like with your bill, with the assistance, everything will be more efficient for the judges.
Yeah, I would hope so. I think some of the drafting and some of the legal research and review, you can write a bench memo and identify the issues. And if there's something cutting edge, the clerk, that the judge is not going to be familiar with, the clerk can look into that. I mean, a lot of times you're drafting a brief and you assume you have an experienced litigator as a judge, right? I mean, most judges are, come from litigation background, then they're experienced, but they may have done family law and now they're doing a commercial case, or they may have done workman comp and now they're doing some sort of statutory claim. And so the judges are they're not going to be familiar with everything, particularly if they're new in the division. You look at the federal judiciary model, the judges are generalists. So you have somebody like me, you put me on the bench, you give me a patent case, I'd have to do some work to come up to speed on a patent case because I haven't done a great deal of patent litigation. So there's always going to be something that the judge is going to need help on. And that's not a criticism of the judiciary. It's just when you have either in the federal judiciary is you have generalist judges, right? Because any given federal district judge, they don't sit in divisions. They're doing criminal, they're doing civil work, they're doing all manner of federal statutory work. They're sitting in diversity, doing common law, state law claims, and a variety of other things like patent, admiralty, whatever. Same thing with circuit court judges. They get shifted from division to division every couple of years. Generally, you may have somebody in a new felony division who is a family law practitioner and did commercial litigation, or you may have a civil litigator who ends up in a family division, and they could certainly use a law clerk.
And when we talk about law clerk, are these going to be, would they be attorneys working?
Yeah, I mean, I envision it would probably be an early career attorney, somebody out of law school or maybe with a couple of years experience based upon the salary that I proposed in the bill. The salary is pretty modest. I mean, it's decent. You can live on it, but it's certainly kind of an entry level or early career type of position. If they're experienced clerks, then that's great. But, generally speaking, a lot of the law clerks, even in the federal system, they're usually early career. There are some people who stay on, even some of my contemporaries are still clerking or just recently left from where they were clerking to go into the private sector. But yeah, I mean, I think it would be generally speaking, 0 to 5 year lawyers, which is, if we could pay more, we could probably get more experienced lawyers at some point on the pay scale. You'd say, let's just authorize more circuit court judges instead of having law clerks. But I think we probably need more circuit court judges, at least in some jurisdictions and some divisions. I know we've had 6 new county court judges in Hillsborough, and some of those, by the way, have been assigned to civil divisions, to circuit civil divisions. And that has noticeably alleviated the difficulties obtaining hearing times. The courts are working, both at the county and circuit levels, are working more efficiently now than they were at the beginning of my career. And I attribute that at least in part to the additional judgeships. And So that just kind of shows if you put a modest amount of resources into the court system, you can really get a good incremental improvement in the efficiency of the judiciary.
And there's kind of like a sliding scale in terms of what the salaries would be for these law clerks based on the region they'd be working, correct?
Yeah, we did adopt the model, which is, I think, in South Florida and to a lesser extent in Hillsborough and Orange and some of the more urban areas of Central Florida. There, the cost of living is a little higher than maybe in parts of the Panhandle or North Central Florida, and so we did kind of try to stay on that model where there's a little bit of a locality pay, if you will.
Understood. It seems to me like since COVID, all the courts have had these case management plans they've required.
Mhm.
It's almost been like a federalization of the
Right.
state courts. Isn't this kind of a natural progression of that, given what your basis for doing it was?
Yeah, that's a very good point. And I'm glad you brought that up. The judges are putting folks on 1 year, 18-month, 2 year trial plans. And that's fine. I think we should get the cases through the courts a little faster than maybe has been traditional, particularly in the state courts. But that presupposes that I'm going to be able to file a motion to compel and get in within a month to adjudicate my motion to compel it. If I need a case management conference, I need to be able to get in on my case management conference. If I file for summary judgment, I need to get in on summary judgment at the beginning of the case. Sometimes you file a motion to dismiss and nobody sets it for hearing, and it'll sit there for 6 months or a year. In the federal court, you file the motion to dismiss. You have a 2 or 3 week return date. If you need more time, you can usually get a courtesy extension or two, but basically that's going to be briefed up within a couple of months. And the judge is basically going to decide that on the papers, and then the case will move forward, and the case will move forward regardless. But there are some case events. For example, you propound discovery and somebody moves to stay discovery for whatever reason. And if you can't get in front of the judge, no matter whether it's a meritorious or frivolous motion, you're going to be sitting there for 3 or 4 months. As a practical matter, you're going to be waiting for a hearing and the case isn't going to move forward. You don't have that issue in the federal judiciary, because the motions tend to get adjudicated quicker, sometimes on the papers. I mean, the way I perceive a circuit civil division working, and you use the traffic cop analogy, is essentially the judge has the capacity, just barely, but they have the capacity to do what's in front of them, what's been calendared on their docket that day. Then they take things home, work on those in the night, or on the weekend. But they really only have the capacity to do what's basically pushed in front of them by their calendar. They're not being able to police the docket, if you will, and look, hey, there's this motion that's being fully briefed. I can just do a written order on that and move that case forward. They don't have the time or the bandwidth to do that type of work. That's another thing, that there's a lot of things in the state court system that could be done on the papers. And in some business divisions, that there is provision to decide motions on the papers. I know Pinellas they have a court rule that you can ask for a decision on the papers. But if the judge doesn't have time for that hearing, and so then you resort to seeking a decision on the papers, the chances, again, that the judge is going to have time to rule on the papers, which may take longer than having a hearing, is pretty slim.
Understood. Have you talked to any of the judges? I mean, we talked about that, we obviously would love to get more circuit court judges. This is a cheaper alternative to that. I would love to see both, obviously.
Right, sure. Yeah,
But
absolutely.
are you concerned, or do you hear about judicial burnout based on what's going on?
Yeah, I mean, I would be concerned about that. I've seen some judges in Hillsborough will go so far as to issue orders. I mean, I've been at church before and I've gotten an order. And I'm sure the judge went to worship at a different time, depending on what their persuasion is. I'm not criticizing anyone on that basis. In fact, someone's working on Sunday morning. If the judge is working on Sunday morning, it kind of says to me that, we need to put more resources into the judiciary. I mean, there have been assertions that, not all judges are pushing their dockets along. And that concerns me as well. I think that needs to be looked into if people aren't being diligent. But I think far more is that the judiciary is overburdened. I've had judges say to me, in hearings in open court, that I don't have the resources to do my job. Essentially, not quite as bluntly as that, but certainly in one case I had late last year, a judge basically told me she didn't have the resources that she needed. And that kind of upset me. And I should really, it wasn't so much the staffing as the technology. She said she didn't have a Westlaw access. And that concerned me. It just really concerns me. We have courts to decide disputes. I mean, the alternative you see in countries where disputes are not adjudicated fairly or even quickly, you see people take matters into their own hands. You see, essentially the organized crime. If you don't, you can just decide disputes in court, or you can decide disputes in other ways. And other ways are inherently inferior to the court. The court's not perfect. It's a little slow. It's kind of expensive. But basically it works. Basically the court system works. And some of my colleagues think the court system doesn't work, and people have bandied about terms like judicial hellhole, which kind of offends me. I've spent my whole adult life trying to improve the judiciary, either as a legislator or J&C commissioner or a law clerk or just a practitioner trying to make a living and move my own cases along. And that kind of saddens me that people would say that. And certainly to the extent there's an opportunity to improve the judiciary, we should be taking those opportunities and running with them.
Absolutely. And, the efficiency of the judiciary obviously helps all trial lawyers
Right.
move cases, get decisions,
Mhm.
all of that. What would you say to somebody who's not a lawyer as to why this bill is so important? Why should they care?
Well, they should care because the most common difficult conversation that I have with a client is when I explain to them the limitations of the justice system. I mean, I literally have clients, they'll file a lawsuit or send a demand letter, or we'll be at a very early stage, and they're like, when do we go to court? And I'm like, maybe in a year or two. And they're always shocked when I tell them that. I mean, they're shocked. My wife, she's not a lawyer, but she'll, she knows about some of my cases, because I'll come out and I'll be worked up about something or other, and she'll say, oh, that case is still going, and it's not even, it might be for a year, the case might not even be especially old. I've gotten cases, usually I'm the second or third lawyer on the case. Like I've gotten cases from 2018, 2019. Those cases are still sitting on somebody's docket. Someone may have sent those to me 6 months or a year ago. And so I'm trying to work them up and get them resolved. But there are cases that have sat for longer than that. And that's just, sometimes by the time you get a case to trial, people just aren't that upset about whatever brought them to court in the first place. You get that. And maybe that's a good thing. But the cases need to move quicker. A lot of people have divorces, for example. That's probably one of the most common things to bring someone in. Divorces or low-level criminal matters are probably what bring most people before the court in terms of volume. And the criminal system moves pretty well because we got speedy trial and everything like that. The family cases tend to linger. How many times have you heard someone, oh, I'm trying to divorce my husband and the case is taken forever, and they want to move on to a new relationship or start a business, and they feel hampered by that. They're still not only dealing with their ex over kids or paying support or alimony, but actually not even having the divorce resolved. And you hear that a lot. That concerns people. And then you have people who will just say, I have been wronged. I want to seek justice in the courts, but either due to the expense or the delay, it just doesn't seem like a good use of resources on balance. You have a lot of people who don't even go to the courts because of the perception that they're clogged up, or that they're inefficient, or they're not going to get a fair outcome at a reasonable amount of expenditure and a reasonable amount of time. And I'm sorry to say, a lot of times that's true. And then I guess the last thing I'll add is, it just as, as a practitioner, and I think lay people can understand this, is it's very inefficient if the case gets dragged out. I mean, you have things in your short-term memory and your long-term memory. And if you can't get a hearing for 6 months, you put the file down, you go and do something else with your time, and then you come back, you almost have to refamiliarize yourself with the file. It's not efficient for the attorney. It's not efficient for the client. And then it's frankly, sometimes the judges have moved on. By the time you get a hearing, you get a new judge. They have to come up to speed on the case. It's just you could have a whole other model. Really, you could do a case in a couple months if everyone agreed you're going to work one case at a time. Like we could have a system where lawyers have one case at a time. You do all the discovery and all the stuff. You could do it in a couple of weeks in a small case. You could do it in a couple of months in a big case, and then you move on to the next thing, and it'll be really efficient. You get really quick results. I don't know if it's feasible as a business model, but
Right.
you could have a whole different type of justice system as opposed to our system. It takes months and months just to get one thing resolved. So at the risk of rambling, I guess that's
No,
my
and look, Florida's had an explosion in population growth and
Mm.
in terms of rankings throughout the United States. I think our budget is among the lowest in terms
Right.
of resources poured into the courts.
Mhm.
This sounds like it would be something that would bring us more into what a lot of other states do.
Yeah, I think so. I mean, I've litigated cases in New York. They certainly have much more ample staffing. I'm not advocating that we go and do things the way we do them in New York. I left New York. I didn't really like New York, frankly. I'm sorry to say, but at least their court system seemed well resourced. There are other issues with the New York court system, of course, but at least they had law clerks. It's not infeasible or an excessive budgetary burden to have law clerks. And and frankly, government spends money on so many things that frankly government shouldn't be spending money on. I don't think law clerks is what's gonna put our budget out of balance. I think there's a lot of government waste, and I speak about that in other contexts, of course, but and we can definitely afford these law clerks. It's just a matter of political will and for the leadership and the advocacy groups. There's no there's no natural well-resourced industry that's going to fight for this. I mean, maybe the trial lawyers would, maybe certainly I don't think the insurance companies would. I don't know that the banks would, so it's maybe they would, maybe they can't get their foreclosures. If there's another recession and the banks can't get their foreclosures through, then maybe someone's gonna lobby the legislature for more resources for the judiciary. I don't know, but certainly that's a very good example of where you actually had, at the time of COVID, I guess there was a recession, if you will. At the time of COVID, you still had foreclosures from the last recessions. You had a whole business cycle that was still we were litigating a whole business cycle ago in the courts. I mean, 2020, I was, again, like people, sometimes I'm the second or third or fourth lawyer on a file. I was defending foreclosures from the previous
Right.
business cycle, something that went down in 2008, for example. I was litigating the results of that in 2020, 2021. So,
Well, let me ask you this. What needs to happen at this point for this bill to gain some traction?
at this point, I mean, we're pretty far along into a session. I'm not gonna blow smoke around and pretend like it's a good situation for this bill. I mean, someone would need to reset a hearing of the Civil Justice Subcommittee and get the chairman to hear my bill. I mean, the pushback on the bill is the fiscal, but we do pet projects that cost as much as $1 billion. The fiscal on this, at a very high estimate would be 50 million. I think at a low end estimate it would be 15 million. I guess there are obviously different price points. If you limited it, you could limit it to certain counties. You could limit it to, say, the civil division, where I think the need for law clerks may be the most acute. You could do a pilot program. You could also substitute the law clerks for some of the pool clerks. So there's different ways to slice and dice it, but I think certainly it's a significant amount of money, but in the scheme of 120, 115, $120 billion budget, in the scheme of judiciary being by far the smallest silo that we spend money on, and that this is a core function of government. I mean, if government did nothing other than police, courts, and jails, yeah, that'd be a pretty decent start for government. And the fact we do tens of billions of dollars on things that are not necessarily public goods, they're private goods. Maybe we should supply them, but certainly not core functions of government. And then we say that we don't have the resources to make sure our cases move through the courts. I mean, I think that's a deficiency of government.
Well, Representative Beltran, I can't thank you enough for coming on here and talking with me. For our members, for FLABOTA members, for trial lawyers, for judges, for anybody who cares about this issue, what can we do to help you?
Well, I mean, a lot of people, first of all, I appreciate a lot of the folks in the judiciary, a lot of practicing attorneys have reached out on this bill. I appreciate everyone's comments and support, both on social media and contacting my office, or people see me at events and come over and talk about the bill. So I very much appreciate that. I mean, obviously, if you know the chairman who are involved in this, obviously, be polite, but, reach out and let them know your concerns. If you know folks in the leadership, everyone's got a state rep, everyone's got a state senator, right? So, and everyone votes for governor and so forth. So let those folks know your thoughts, whether this session or in a future session. I hope, I hope eventually we implement this. It really is that, along probably with some sort of statewide docketing system, so that you have something similar to Pacer, where I can go in any county and I can search across counties for cases, and it's kind of a uniform system to easily pull documents. The law clerks and some sort of improved e-filing system, those are probably the two most important things for our justice system at this point. We've done, I mean, obviously we've created a new appellate court. A lot of the judiciary is churned in the last 10 years, I think for the better. I guess it depends on people's perspective, but I think certainly the quality, integrity, the pedigree of a lot of our judiciary is very good at this point. And but it's a constant process. It's a constant process to improve the functions of government. And I think this would be transformational, maybe a little too presumptuous, but I certainly think it would be an extremely valuable step. And so I hope this is implemented, if not now, then in the future.
Well, again, I know I love the idea, and it's something that I think would really benefit our clients, our practices, and just the administration of justice, which is at the forefront of what FLABOTA stands for. Can you let us know if anyone would like to get in touch with you or get more information? How could they go and do that?
So the bill text is on the Florida House website. It's myfloridahouse.gov. From there, the easiest way is you click on Mike Beltran's filed bills. You would go down to Representatives Mike Beltran, and you'll be able to find all my bills there. You can also look the bill up by bill number, although we don't really sit around and memorize the bill number. But you could also look the bill up by bill number. If you want to talk about the bill or let us know the thoughts, there's a contact page on my House webpage, and then also you can find the chairman. It's been referred to Civil Justice, Justice Appropriations, and Judiciary, so you can find those chairmen on the website and let them know that you'd like to see the bill move. You can contact the speaker in the same way. You could find that contact at myfloridahouse.gov.
I also wanted to point out on the Florida Bar News website, which is, I think, how I found out about this, the November 28, 2023 article, measure would provide each circuit judge a law clerk. That was featured in there, and there's some information in there as well. Well, Representative Beltran, it has been a pleasure, and I hope that we can have you on here again, and we can maybe you'll be a little further along on this project.
I hope so. It was a pleasure talking to you. Thanks for your interest in the bill, and I hope this was informative for your viewers.
Absolutely. Well, on behalf of FLABOTA, I am FLABOTA President Jeff Adelman, producer Mitchell Chester. And if you're interested in listening to this program, you can get it on Spotify, Apple Podcasts, or anywhere, any podcast platform that you prefer. Until next time, thank you for listening. This is the FLABOTA Podcast.
The preservation of the civil jury trial, also referred to as justice by the people, is the primary purpose of the American Board of Trial Advocates. We seek attorneys who display skill, civility, and integrity, to help younger attorneys achieve a higher level of trial advocacy, and to educate the public about the vital importance of the Seventh Amendment to the United States Constitution. Thomas Jefferson was of the opinion that the right to trial by a jury of fellow citizens was a more important safeguard of personal liberty than even the right to vote. With a jury, the rights and duties of each of us will be decided by our fellow citizens, not by a bureaucrat or governmental functionary. The American Board of Trial Advocates embraces this philosophy of Jefferson, and is a leader in the fight to preserve and protect the rights of every American to a jury trial. The organization is dedicated to justice by the people. For more information, contact us at abotaftl@gmail.com. The 17th Judicial Circuit, in a project advocated by the Fort Lauderdale chapter of the American Board of Trial Advocates, expanded use and access to the court's emergency alert system. You can register for email and text messages from the court about emergency closures and cancellations. To sign up, please visit the court's website at 17th.flcourts.org. This podcast was produced on December 8, 2023 by Jeff Adelman and Mitch Chester, for the Florida chapters of the American Board of Trial Advocates, and the Fort Lauderdale chapter.